So hello everybody and welcome to our multi-country webinar with respect to residency of private clients and global mobility following the pandemic, brought you by Taxant. Today we will be presenting an overview of the impact on the pandemic with respect to private clients and their global mobility, and we are going to do this via a case study presenting the tax implications from the perspective of 5 jurisdictions, that is Cyprus, Greece, Italy, Switzerland, and the UK. Now, before I move on to the case study and to my colleagues, I would like to mention a few issues that you need to keep in mind. We would like to hear your questions, so keep an eye on the question and answer box to post any questions that you may have, and all your questions will be posted and answered at the end of this session. The presentation, the PowerPoint slides of the today's session will be, of course, shared among the attendees at the end of this session. And at the end of the presentation, you will notice the contact details of all the attendees, all the speakers, I apologize. And therefore, in case you have any specific questions, feel free to contact with them. Next slide, please. Now, the agenda for today, it will be the introduction to our case study, and then each country will present the tax implications from their perspective. Then all the countries, all the speakers will have a panel discussion to discuss what are the current updates of private clients and their global mobility. And we also have a guest speaker from our Taxan member firm in Sweden, Mr. Anders, to share also his experience about global mobility. At the end, we are going to have the Q&A session, so feel free to pose your questions in the Q&A box. Next slide, please. Now, the background of our case study is that what we typically have in our business, we have Mr. and Mrs. X, the family that they are resident in state A for their entire life. State A, for example, would be a Central European country or USA, Russia, whatsoever. And they are contemplating to relocate to another jurisdiction. Today we'll be presenting, as I mentioned before, the implications of 5 jurisdictions, and they are not moving or relocating not just for tax reasons, but they also consider other reasons as well, such as education, climate, business opportunity, lifestyle, and so on. The key issue of our webinar is to tax considerations that Mr. and Mrs. X, the family, need to consider, how to plan their wealth following their change of residence, and how to minimize their tax risk. Now, in order to do that, they usually consider the tax implications from a threefold perspective. Next slide, please. Now, to begin with, the family should consider the tax implications from the departed jurisdiction, i.e. the state aid. And this will be, for example, how to get a tax clearance from the departed jurisdiction and be removed from the tax register of such jurisdiction and pay any taxes, if there are any taxes, such as exit taxes and so forth. Next, the family needs to also consider the tax implications of the landing jurisdiction. And these implications, we are going to see them today, meaning of how their wealth will be taxed following the move residence from the departed jurisdiction to the landing jurisdiction. And finally, last but not least, because high net worth individuals are considered to be highly mobile and they also have assets around the world, they may be found to be tax resident in more than one jurisdiction. The very fact that a person is resident in another jurisdiction does not prohibit another jurisdiction to tax him. So we also advise clients of how not to be taxed in any other jurisdiction and end up being dual resident. Next slide, please. Now, here we have considered the various sources of income of the family, and the sources of income will be both income from passive income and active income, and also they have their own capital assets, and their passive income will typically be dividends, interest, and capital gains tax. Although high net worth individuals, from our experience, they don't usually have active income, but in this example, in this case study, we also have some employment income, and also they own some assets, so they need to have immovable property and consider wealth and inheritance taxes. Next slide, please. Now, the various tax authorities around the world, what they typically do in order to consider tax residents, such high net worth individuals, and they are trying to tax them, they use a combination of tax residence criteria, both objective and subjective. The objective criteria will be the physical presence test, the habitual abode, which will be the number of days, for example, 123 days, or there will be their nationality, their passport. Also, they use subjective criteria as well, and such subjective criteria will be the permanent home or their personal and economic relations, the so-called center of vital interest, that they typically look at their occupation, their family, where they vote, where they go out, what is their cultural activities, what are their interests, and so forth. Next slide, please. And now this is our case study. I will be hand over to my colleague in Tax and Cyprus, Kostas Sava. Kostas Sava is a tax partner in Tax Cyprus and will be providing the tax implications from the Cypriot tax perspective. Costa.
Christos, thank you very much. First of all, I want to thank everybody attending our seminar. We are going to try to be as specific as possible within our time limit and explain a couple of things based on what my colleague have just mentioned. So I will go very quick in Cyprus and saying that we live, first of all, we live in a progressive globalization. People are moving around all the time, either because they need to move due to the change of work, or they are wealthy enough and they want to live in a more attractive place for their life, for their kids. So we see the last decade especially a lot of people moving around all the time. From the perspective of workers, I would have said that I was reading a poll a few days ago saying that the last year more than 20 million people moved around their permanent houses to get job in another country. So saying that, every country, and among them Cyprus, is providing benefits or giving a lot of options to these people, either, as I said, workers or high net worth individuals, to move to Cyprus and spend the rest of their lives or their working life. So explaining, before we go to explain these criteria, we should give a very thoroughly explanation of what Cyprus consider as resident, and then we go to more details. So Cyprus considers people to be tax resident here if they live in Cyprus more than 183 days. Very simple rule. The only thing that a person needs to prove is that lives in Cyprus more than 183 days. A few years ago, to be more attractive, Cyprus has introduced a new rule. So the 183 days rule still exists, but in addition, the government has introduced the so-called 60-day rule. This rule, obviously, to avoid any problems with the OECD tiebreaker rules, it's fit and it's considered to be applicable to these cases. So, in order to become a Cyprus tax resident, you have to be here 60 days in one calendar year. So within 1 year, 60 days is more than enough to be here and considered as tax resident. Nevertheless, in addition, as I said, to avoid any problems with our treaty partners, we have established more rules and criteria, which are the following. This person, this individual, should not be tax resident in any other country of the world. It should not be more than 183 days in any other place. And in addition, this person should have permanent home in Cyprus, either owned or rented, and he or she should carry a business in Cyprus, an office, either as an employee or as a director in a company. Next slide, please. So, establishing now that this is the way to become a resident, we should move a little bit more to what is the benefit that the workers might have, that they have active income, and what the high net worth individuals' benefit will be if they become resident in Cyprus, tax resident in Cyprus, which usually the high net worth individual, they have passive income. So, from the side of the workers that they have, as I said, active income, the tax rate is between 0% to 35%. So, it's the first 20,000 is tax-free, and from there on, it's progressive up to 35%. Now, Cyprus, in order to attract workers, they have introduced two rules. First rule is that for employees that they earn less than 100,000 in a year, they are eligible a 20% discount on their salaries, which is approximately, it should be lower than 8,500. For high payers, meaning that they earn more than 100,000, the Cyprus providing a 50% exemption in their income. For example, if I can say just a very quick example, if someone comes to Cyprus and is a director of a multinational entity and he earns or she earns 100,000 euro, then is eligible for a 50% discount, meaning that she will pay taxes only on the 50,000 euro, which is a very, very attractive benefit. On the other hand, for people that they have passive income, obviously being a Cyprus tax resident, even if you have passive income, you should have paid high taxes as any other jurisdiction in Europe. And for that, the government has introduced the so-called non-dom regime. Next slide, please. So, the non-dom regime, just to explain in a few words, is for all people that they are familiar with the UK non-dom regime. Obviously, they have a good understanding, but nevertheless, a non-dom regime means that a resident of Cyprus, a tax resident of Cyprus, can be a domicile either by origin or by choice. And whoever is not either by origin or by choice is considered as non-domicile. So if you are a foreign and you are considered as non-domicile, then you will not pay taxes on your passive income. So very quick, if you are a Cyprus tax resident and you are a non-dom tax resident, you will have a lot of exemptions. For example, profits from sale of securities, income from redemption of units, forex gains, and so on. Next slide, please. So in Cyprus, we say that someone is coming to Cyprus, is becoming tax resident of Cyprus, is claiming and that is non-domicile in Cyprus, and is avoiding to pay taxes on his or her passive income. From there on, Cyprus has no wealth tax or inheritance or gift tax. This gives the option and the chance to people that they are moving to Cyprus to plan for their estate taxes. There is no real estate tax in Cyprus. There is no capital gains tax in Cyprus unless you own a property situated in Cyprus. And there is no exit tax at the moment for individuals. Next slide, please. So before I give the microphone to my colleague in Greece, I will go through very quick, again, a very short repeating. If you come to Cyprus, you can become a tax resident of Cyprus if you are 60 days here, if you are not tax resident in any other place in the world, and obviously if you have a home and an office in Cyprus. In addition, you can become a non-dom and pay no taxes on your passive income. Thank you very much. Now I will pass the microphone to my colleague in Greece.
Hello, this is Athens talking. Thank you in my turn for all of you attending this webinar. What we're having here, and please next slide, following the standard case that Christos has presented, a married couple has been residing outside Greece for its entire life and wishes to relocate in Greece. So besides the beautiful Greek weather and the Greek islands that that couple wish to enjoy, it shall also contemplate of any tax aspects of its relocation. So moving to the next slide, what is crucial for determining an individual's tax residence is the place of an individual's permanent or main home, or his habitual abode, or the center of vital interest. By vital interest, even though it's not a term that has been explicitly defined in Greek tax laws, following past provisions as well as Greek jurisprudence, as vital interests may be indicated several elements, such as the ownership of assets in Greece by an individual, probably the citizenship, or even social security registration in Greece, or again the place where the family of such individual resides. Alternatively, the other let's say parameter that by which the individual tax residence may be determined is the stay of an individual in Greece over 183 days within any 12-month period. So moving to the next slide, Greece has quite recently introduced a triple set of tax incentives for individuals wishing to relocate in Greece. First, we have the high net worth individual tax regime, the key benefit of which is that an annual fixed amount of 100,000 euro substitutes any Greek income tax on foreign source income. And the conditions for qualifying, for an individual to qualify such regime, twofold. First, the individual shall have resided outside Greece 7 out of 8 years prior qualification. And an individual shall make an investment in Greece of at least 500,000 euro within 3 years from application. Finally, an individual may be subject to such regime for up to 15 years. The second set of incentives refers to retirees. So moving to the next slide, as you may notice, the key incentive for such regime is that any foreign source income is taxed at the 7% flat tax rate. And in order an individual to qualify for such regime, he shall receive a foreign source pension and reside outside Greece for at least 5 out of 6 years prior to application. Again, as in the case of the high net worth individual tax regime, an individual may be subject to such regime for up to 15 years. And moving on to the next slide, and the final set of key tax incentives for executives, or as other jurisdictions may call it, impatriates tax regime. A 50% tax break is granted on Greek salary or business income for any individual being subject to such regime. The key difference of this regime compared to the previous one is that an alternative taxation is provided for foreign source income as regards the previous regimes. On the contrary, the executive regime provides for alternative taxation of Greek source income, and in particular of Greek salary and business income. In order an individual to qualify for such regime, he shall have been a non-Greek tax resident for 5 out of 6 years prior to application. Additionally, the individual shall be hired by a Greek employer or commence business activity in Greece. And the individual shall have an intention to stay in Greece for at least 2 years. This regime, the duration of such regime, is up to 7 years. So moving on to the next slide, what you may notice is actually this slide sums up all the above mentioned. As regards passive income, you may notice that high net worth tax regime and the retiree tax regime is quite beneficial for individuals wishing to relocate who also have a respectable, let's say, amount of passive income from foreign sources, from non-Greek sources. And moving on to the next slide, as regards active income, this is, let's say, more beneficial for executives wishing to be subject to an alternative mode of taxation for any employment income, Greek employment income. And last but not least, as regards capital assets, moving to the next slide. Capital assets, well, there is no wealth tax in Greece whatsoever. There is no real estate property tax, an annual real estate property tax for Greek Cyprus real estate. And also an inheritance and gift tax up to 10, 20 or 40%, depending on the kinship of the deceased and the heir, or let's say the donor and the donee. So that is all from Greece. Moving on, leaving the floor to my colleagues from Italy.
Hello, everyone. Thanks for attending the webinar. Well, in the next few minutes, I'll briefly explain you two attractive tax regimes for new Italian residents based on the background described. Well, these regimes are quite similar to the ones just explained, They are the high net worth regime and the impatriate regime. Before analyzing these regimes, let's have a look at the criteria to be considered resident in Italy for tax purposes. Next slide, please. Well, the requirements which must be met alternately for more than 183 days in a calendar year are the registration in the Register of Resident Population, domicile in Italy, and the habitual vote in Italy. Well, the first one is a more formal requirement, while the other two are more substantial. And in this regard, the Italian tax authorities usually challenge the tax residents on the basis of the last two requirements, focusing mainly on the center of personal and economic interests. In the next slide, we can see the key points of the high net worth regime. It is addressed to non-resident individuals transferring their tax residence to Italy and that have not been resident in Italy for tax purposes for 9 out of 10 of the previous years. And under this regime, the taxpayers are required to pay a lump sum substitute tax of 100,000 euros per year instead of the ordinary taxation. And this lump sum taxation is due on all the non-Italian sourced income. And on the other hand, of course, they are still required to pay the ordinary income tax on Italian sourced income. And this regime can be further extended to family members at a cost of 25,000 euros per member per year. And finally, about the duration, the regime lasts for a maximum of 15 years. And other advantages that can be mentioned are, for example, the exemptions from inheritance and gift tax, tax monitoring obligations, and wealth tax. Of course, all these exemptions relate to assets held abroad. Moving to the next slide, we will analyze the impatriate regime. And this regime, like the previous one, applies to individuals that transfer their tax residence in Italy. But the attractive aspect of this regime is that it offers a beneficial tax treatment according to which the Italian sourced employment and self-employment income are subject to individual income tax only on 30% of their amount, or 10% in case the taxpayer moves the residence to one of the southern Italian regions. In this respect, there are two alternative sets of requirements to be met for the application of this regime. The first one requires that individuals have not been resident in Italy for tax purposes for the 2 fiscal years preceding the transfer to Italy, and the individuals remain tax resident in Italy for at least 2 years, and mainly perform their working activity in Italy. That means at least 183 days in a year. Or in the second scenario, we have that individuals must continuously work for at least 24 months abroad and have a university education title, or they studied abroad for more than 24 months and they got a university title. The regime is granted for a period of 5 years, starting from the year when the individual moves the tax residence to Italy. And moreover, under certain conditions, it is granted for additional 5 years, and the income is exempt only for 50% in this case. Well, to better understand the advantages of these regimes, in the next slide, we can make a comparison with the ordinary regime, and we can see that, for example, for passive income, such as dividend, interest, capital gains, that are sourced abroad, they are covered by the lump sum taxation of 100,000 euros instead of the application of the tax rate of 26% provided for by the ordinary regime. And the same applies to rental income from property located abroad, that in case of ordinary regime is taxed at a progressive tax rate. In the next slide, we see that in terms of active income, There are two different benefits depending on which regime we apply. With the high net worth regime, the employment income, stock options, and bonus are covered by the lump sum taxation for the activities carried out abroad. And on the other hand, if you apply for the expatriates regime, we will have an exemption for the activity carried out in Italy. And in the next slide, finally, we see the capital assets. Well, in relation to capital assets, Italian individuals have to pay wealth taxes on assets held abroad and are obliged to report all these assets in the tax return. Well, considering that these may discourage some high net worth individuals from moving to Italy, the beneficial regime exempts the taxpayer from these obligations. And finally, in terms of inheritance and gift tax, the Italian tax law provides for a taxation that ranges from 4 to 8% with certain thresholds. And by applying the high net worth regime, these taxes are not due for assets held abroad. Well, that's all by my side, and thanks for the attention. I now pass on to my colleague René from Tax and Switzerland Tax Partner.
Thank you, Marisana, and welcome from my side as well. In the next few minutes, I'm walking you through some of the key features of the Swiss tax system which an individual needs to take into account when relocating to Switzerland. Next slide, please. Next slide. An individual is deemed to be tax resident under Swiss domestic law if he has a physical presence in Switzerland and if one of the three conditions presented on the slide are met. The first category of tax residents refers to individuals who have an intention to permanently establish an habitual abode. If there is no such intention, a taxpayer can nevertheless establish a tax residence if he exercises a gainful activity for a consecutive period of at least 30 days, or if he stays in Switzerland without a gainful activity for a consecutive period of at least 90 days. There's a lot of case law on how these three categories of tax residents need to be interpreted. Due to time constraint, I'm not going to dive into this discussion. The fact of the matter is, if an individual becomes resident in Switzerland, he becomes in principle subject to unlimited taxation in Switzerland on his worldwide income and wealth. Please note that the Swiss tax system is structured around three layers of government: the federal, the cantonal, and the communal government. Income tax is levied at all three layers, while the wealth tax is levied by the cantons and communes only. Next slide, please. Next slide. Ladies and gentlemen, there is no slide before, sorry for that. Ladies and gentlemen, there is one important exemption from the worldwide taxation, the so-called lump sum taxation. What are the key features of the lump sum taxation? Under the lump sum tax regime, taxes are levied on a deemed income. This is a lump sum that is determined on the basis of an estimate of the annual living costs of the taxpayer. The law provides for rules for estimating the living costs. The cost of living, and therefore the tax base, is determined as 7 times the annual rents, the annual rental costs of the taxpayer and his dependents. For instance, the annual rent of the mansion of the taxpayer he rented in Switzerland is 120,000 Swiss francs. This would result in a tax base of 840,000 Swiss francs. The minimum tax base must be at least 400,000 francs. Next slide, please. Please note only non-Swiss citizens who do not pursue a gainful activity in Switzerland and who have not been tax resident in Switzerland for the last 10 years or have never been tax resident in Switzerland and who establish a tax resident in Switzerland can opt for the lump sum taxation. Next slide, please. This slide provides you with an overview of the taxation of income from Swiss and foreign income. One of the most important and unique features of the Swiss income tax is that capital gains derived from private assets are tax-free. For example, Mr. Smith sells his shares in his company based in Italy and realizes a capital gain of 20 million francs. This amount will be exempt from his income tax in Switzerland. Next slide. Next slide, please. In addition to the income tax and wealth tax I have just briefly outlined, individuals relocating to Switzerland also need to keep in mind that there are gift and inheritance taxes at cantonal level. But please note, in general, inheritance and gifts to spouses are tax-free in all cantons. Inheritance and gifts to direct children are tax-free in most of the cantons. Next slide. Next slide, please. Let's have a look at the income and wealth tax rates. As I said at the beginning, income taxes are levied at the federal and at the cantonal communal level. The chart illustrates the top marginal rates of some selected cantons and communes in Switzerland. The rates can vary significantly. For example, the cantons of Schwyz and Zug provide income tax rates of around 22% compared to Zurich with 40% or Geneva with 45%. The same applies to the wealth tax. The canton of Schwyz is the most attractive canton in Switzerland, followed by the canton of Zug. I'm going to pass on to my colleague, Jonathan, from Taxant UK. Please, Jonathan.
Thank you very much, René. Today we're going to be covering from a UK perspective the concept of tax residence in the UK, what that means for you, and also explore our non-domicile regime and what that may mean when perhaps looking to move to the UK or perhaps even leaving the UK as well. So please can we go to the next slide. So the UK tax system is broadly based on a number of nights that you spend in the year. So the good news is we have a test system that determines a number of nights that you can spend in the UK to either become a UK tax resident or to avoid spending to make sure you are non-UK tax residents. That can vary year on year, and that number of days is dependent on the number of ties that you have to the UK. So that may look at things like accommodation, your family ties, how many years you've been UK tax resident, and also what are you doing in the UK? Are you working? And also, do you have available homes and accommodation? It can vary each year, depending on how many ties you have to the UK. As you can expect, the more ties that you have closer to the UK, the harder it is to shake off UK tax residents, and it works on the other side of the coin as well. In the context of the pandemic, in terms of the midnight nights that you can spend in the UK, we have seen the UK government, there are exceptional days that you can take into account that aren't considered residence days. They are exceptional circumstances, and you should get advice if you're unsure over the past year and a half. But in terms of tax residence and what that means for you as a taxpayer in the UK, you could pay tax up to 45% on income. You could pay tax up to 28% on capital gains, such as on the sale of property. It's actually a bit lower for sales of shares at 20%. And you could even be subject to inheritance tax at up to 40%, which is on death that you pay tax on all of your worldwide assets. Next slide, please. Next slide, please. We go on to the next slide, sorry. Thanks. So in terms of the UK tax regime, we have three different types of taxpayers here. We have UK residents. UK residents are normally taxed on their worldwide income and gains. They're taxed on absolutely on everything that they receive. Non-residents are normally taxed on capital gains deriving from UK property, and they can also be taxed on UK income. So if you're non-resident and you have a rental property in London, for example, you could be actually taxed up to 45%. Now, also in the UK, we've heard today the concept of non-domiciled non-domiciled individuals. Those individuals can also benefit from a special regime in the UK. And if we go on to the next slide, please, I'll explain a bit more detail on how to access that regime and what that means for you. So the concept of domicile, I won't go into in too much detail. But if you're coming to the UK for the first time, your parents are not UK citizens, they've never been UK residents, and you're only here for a short period of time, then you may have a chance to say that you are non-UK domiciled. This could be significantly beneficial for you because the rates which I mentioned before, up to 28%, up to 45%, and up to 40% inheritance tax, could actually be reduced to, in some instances, nil. So if you go on to the next slide, I'll articulate how the non-domicile regime works. So if you from a UK resident and domiciled, so someone who's based here, who's UK domiciled, will be taxed as normal on everything that they receive. But a non-domiciled individual, to the extent that they receive foreign income, so let's say foreign bank interest, foreign capital gains in the year, to the extent that they post those proceeds or money that they've received outside the UK, and they claim a special status on their tax return each year, they may be able to exempt that from taxation in the UK. However, the caveat to this is that if you bring that money to the UK and need to spend it, then you may have to pay tax when you bring it in. So it's always very important. So if you're thinking about accessing this regime or perhaps moving to the UK, it's always important to get advice prior to that point to make sure you review all of your circumstances to see if there's opportunities to accelerate capital events and see if there's any planning required to make sure we file your tax returns on the right basis and make sure we claim non-domicile status. It does cost to access the non-domicile status in some instances after 7 years. It starts at once you've been here for seven out of the past 9 tax years, you have to pay £30,000, and that increases to £60,000 as well. And once you spent 15 years here, you will be deemed UK domiciled, and in advance of that point, there are still some planning opportunities available, and you should always get advice. Even if you want to stay in the UK, there are some benefits which you can still get onto the regime. I'm now going to pass on to Christos to kick off our panel discussion.
Next slide, please. Many thanks, guys, for the insightful tax implications for each country. This is a summary of our case study about the family of Mr. and Mrs. X and what they are considering of. And let me make one question to each country in order to discuss and get into the practical details about our case study. So let me begin with Kostas in Tax and Cyprus. Costa, the Cypriot government seems to introduce, in its effort to attract high net worth individual, a non-domicile regime in Cyprus, which is kind of similar to the UK, for the simple reason that Cyprus is a common law jurisdiction. So was this attractive? Is it widely used in practice from your experience? And please try to be able to be brief, Kostas, just 3-4 minutes.
Thank you, Christos. Thank you for the questions. I will try to be as quick as possible on this. Obviously, for people that they are familiar with common law jurisdictions, they can understand what this exactly is. Just historically, to say that when the UK had all those colonies and people from UK, they were moving to colonies around the world, there was usually in the will and succession law, as in Cyprus, there was this separation between people, domicile and non-domicile. Obviously, the target was to avoid the UK residents to be taxed both in their home country and in the country that in the colony that they were working. That's the historic meaning of the non-dom, just for your understanding. Now, obviously, it was great that we had such a thing in our law, because this gave the opportunity to have a separation between people. And obviously, the UK government many years ago has introduced this very successfully. In Cyprus, it was and it is very successful for two reasons. First of all, obviously, if you are a non-domicile and you don't pay taxes on your passive income, it's by default attractive. So you don't pay taxes on your dividends or your interest. Those was very attractive by default. On the other hand, due to that we are island and it's not easy for some people to live in Cyprus for more than 183 days, the rule of the 60 days rule helped a lot, because obviously to people that they are, as we said, stateless, meaning that they were not in any other jurisdiction tax residents, it was easy for them to come to the island, live for 2 months in a year. It's a sunny island. It's an island that is very attractive especially during the summer months. So these two in combination attracted a lot of high net worth individuals. I would say that we see the last year especially, a lot of people moving in Cyprus to get benefit of this. And obviously, something that we didn't mention at the beginning, this is not 1 or 2, 3 years. By law, it goes up to 17 years. From there on, you are losing your non-domicile status and you are considered as domicile by default. So someone can come to Cyprus and enjoy and benefit from this for 17 years.
Sorry, I was on mute. Many thanks, Kostas. Just let me say that we already have a couple of questions, and feel free to pose your questions because we have the Q&A session in 15 minutes. Let me move to Greece. Anna, your colleague Nikos already, next slide please. Your colleague Nikos already mentioned various tax incentives that the Greek government provided. What are the key considerations that in practice your clients face when moving to Greece? For example, the retire regime or the receiving a foreign source of pension scheme.
Hello from me as well. A few points that they have to have in mind, especially the high net worth individuals. When it comes to clients with corporate structures, they should have in mind the Greek effective management rules. On the other hand, due to their lifestyle, the high net worth individuals usually spend time in many countries, so they should monitor the tax residence rules of each country and have in mind that they should have Greece as the center of their vital interests. On the other hand, what we've seen from clients when it comes to the foreign retirees scheme is that we have clients who may be interested in such scheme, but they have a private pension. In that case, they cannot qualify for this scheme. This is they have to receive a state pension or a retirement group pension. Another concern that we see from employees who are interested in the employment scheme is that in many cases we see that there's no permanent establishment of the employer, and under the specific scheme there should be a permanent establishment of the employer. So we see that this is not a decision that the employee can take only, it is up to the employer as well. And we've seen in general interest during the last year, which was the first year of application of all the schemes. And even though, I mean, we had the difficulties due to the COVID situation and the difficulties in movement, because of the relevant restrictions, we could say that there was some interest, and we think that there will be an increase in the future.
Many thanks, Anna, for your insightful discussion. Let me move on to the tax implications in Italy to Lucas. Luca, in your discussion, you mentioned that there are regimes that let's say, for example, famous football players, they picked up this regime, like the unwanted regime and the high net worth regime. Can they receive this regime, I mean, both? And also, does Italy has any preferential regime for retired people? What is the views from Italy?
So, thank you, Chris. Yes, in connection with your question, no, it's not possible to apply at the same time to both regimes, and therefore the individual and his tax advisor should perform an analysis in order to understand which of the regime would fit better his needs. And for example, if we think to a football player, and they have to analyze whether their income could be divided in two parts: the salary that they receive from the football team, and the image rights, sponsorship, and so on. So if the second part of income is higher than his current salary, probably the high net worth regime should be opted for instead of the impatria regime. On the other hand, if you are, let's say, a normal sportsman with a salary, the impatria regime is the preferential one. Please go to the next slides. I would like to highlight something on this regime and about the future that they may have, because the coronavirus is placing an enormous budget pressure on state and local government. So, in addition, the managing director of the Ministry of Finance, in an audition held in March, stated that every year the loss of tax revenue deriving from such a favorable regime is approximately about 200 million euro. In addition, she said that the favorable regime increase the complexity and are controversial from an horizontal perspective, because the individuals with similar income and asset does not pay the same amount of taxes. So, in addition, there are rumors about the possibility that the new government increase the inheritance and gift tax, or they are going to introduce a wealth tax. So even if, therefore, Italy recognizes the importance to attract people, it continues to face large shortfall due to COVID-19 effects. Therefore, we may not exclude that the Italian government, that in these days is thinking to a reform of the Italian individual tax system, may think to repeal them. And if it is the case, we also have to, the other question would be, what about the people that already applied for it? As far as we know, in some countries, the law clearly provides that in case of repeal, the regime will continue to apply for individuals that already opted for it. But we do not have such provision, and therefore the answer could not be the same. Thank you.
Many thanks, Luca, for the practical, insightful discussion that we received from Italy, and hope the regime will not be repealed and we see more football players going to Italy. So it would be good news. Let me move on to René. René, traditionally, Switzerland attracted a lot of high net worth individuals to move there. From your experience, which countries will typically move to Switzerland in order to get a tax residency there? And what they typically face in practice, I mean, from their departing jurisdiction, the tax authorities there, what do they typically see and face when moving to Switzerland, René?
Yeah, you are totally right, Christos. In particular, during the last couple of months, we have received many requests from individuals to support them in relocating to Switzerland. The requests mainly come from Germany and France, which is comprehensible if we take into account that German and French are our two important national languages. What are the reasons for that? We quite often hear from our clients that they are unhappy with the government's response to COVID-19, and they are very much concerned about tax increases in their jurisdictions. This is one of the main reasons that they think about relocating to Switzerland as a kind of safe harbor. But I mean, you need to be cautious if you relocate to Switzerland and if you invoke the very attractive lump sum regime. We see that foreign tax authorities are questioning the tax residence in Switzerland from this individual, and you see that in particular in the information exchange requests we receive from foreign authorities, in particular from French, Spanish, Italian, and Dutch tax authorities. They are asking the Swiss government for information about foreign individuals who have a nexus to their jurisdictions. So it's quite important that you mitigate this risk. This means for people relocating to Switzerland and invoking a lump sum tax regime that they need to keep record about their stay in Switzerland. In particular, they need to demonstrate that they meet the 90-day test if they do not perform any gainful activity in Switzerland, but they also need to keep precise record about their trips and stay abroad. So this is a really important issue. If you relocate, you need to have a real residence in Switzerland, and you have to make sure that the double tax treaties really protect you from dual residence. Christos?
Thank you, René, for the updates and what is currently happening following the pandemic. And it's very important for clients to know what you mentioned in order to be protected for any unwanted questions of the tax authorities. Moving on to the UK, Jonathan, the UK has been traditionally a pioneer on attracting high net worth individuals, especially with the introduction of the non-domicile regime that is there, I mean, for more than 20 years or more. My question is that now with the pandemic and with all this the discussions that are happening around the world, do you see that the government might abolish or amend the regime in order to attract any taxes? Do you think that there is a likelihood on to increase the tax rate? What is your view from London?
Thanks, Christos. You're right. In terms of the non-domicile regime, whilst we might not have the rolling hills of Italy or Switzerland or the Greek islands, we do have an attractive non-dom regime, and it does allow clients to accumulate, realise and preserve their wealth tax efficiently. In terms of the future of the non-domiciled regime, it's an interesting question. Under the current government, I'm not personally expected, or we haven't heard any news that there's going to be any changes. So that's welcome news for international entrepreneurs and executives. Obviously, with a changing government in future years, anything can happen. In terms of tax rates over the past year or so, especially since the pandemic, there's been a lot of talk about raising tax revenues. At the moment in the UK, we have capital gains almost as low as 20% in some instances. We have income tax up to 45%. So there's a big difference between people that are selling shares and paying 20% tax versus someone that's receiving income from an employment up to 45%. There's been a lot of talk whether they equalise those. That could be in the next. That could be in the next announcement as early as the autumn, but we don't know. But we do think there will be some changes, or perhaps some restrictions to capital gains. But we're not expecting a significant change to the non-dom regime in the next few years.
Okay. Many thanks, Jonathan. And I totally agree with you. The UK was a pioneer on attracting high net worth individuals. And I don't know whether if the Greek islands were in the UK, how many of them will move there since the early 2000s. So let me move to our next guest speaker from Sweden, Andres, who will give a different perspective of advising clients on global mobility. Andrea, I think if I'm not mistaken, please correct me if I'm wrong, you have advising clients for more than 20 years on global mobility. So I would like to give you, let's say 7 to 8 minutes. You can give us them from your perspective and your practical experience. What are the key considerations that they are looking for, and whether you have faced in the past issues of dual residency of such private clients, and whether you have any example of moving abroad and the situation goes wrong. So what will be your advice on such high net worth individuals, Anders?
Thank you, Christos. You're correct. I've been working with this for more than 20 years. I've been listening into the different countries and their descriptions of their different tax regimes, etc. And especially I noted that one of my observations is that a lot of countries have special tax regimes, whether they've had it for a long period, like in the UK, whether it's rather new, as in Italy and in Greece. You have to keep in mind that this might affect the tax treaties. And both in the respect of that, when you look at the tiebreaker rule to determine where the individual has his tax residency, in some countries, the tax regimes results in that you are tax resident, but you're treated as a non-tax resident. That will have an effect when you look at the tiebreaker rule. And in worst case scenario, you will still end up with having treaty residency in the country where you're leaving. And there is also the problem that when it comes to the tiebreaker, that one of my first instructions or recommendations to clients is that when they're moving abroad, make sure that they do not have access to a home in the previous home state. Because in that way, you avoid, in most tax treaties, the problem of having to look at whether you have your center of vital interests. That's always the number one recommendation. Make sure you don't have access to a permanent home in the state that you're leaving. And my other observation from today is that we've heard a lot about hardcore facts about tax rates, tax regimes, but let's not forget that there are other aspects that has to be taken into consideration when you move abroad. It's very important to look at the language. Do I speak the language? Can I make myself understood? What about my family members? Will they be able to make themselves understood? When it looks at the kids, if you have kids and they want to go to school, are there any good schools in the near vicinity? And if you have small kids, are there any daycare centers, or do I need to bring in a nanny? If I want to bring in a nanny, would that be possible from an immigration perspective? But the most important thing to look at is actually your spouse. Will there be something meaningful for her or him to do when you move abroad? Is there any work opportunities? Are there any other activities like clubs or charities? Will there be other countrymen to meet? And you always have to look at all of this. I mean, my experience is that relocations that are purely tax driven there is a big risk that those will end up in some kind of unhappiness. That's very important. And also, we've heard about tax. Don't forget the immigration rules. If it's within the European Union, no problems. But if we're talking about relocation to or from other countries outside of the European Union, you must also look at the immigration issues. Especially I've seen cases where we have families moving in and everything is taken care of with immigration and taxes, everything is settled. And then they come and said, okay, but we have to bring our nanny in. And they haven't looked at the immigration issues for the nanny. And I've seen nannies coming to Sweden, they're having just wait for 1 to 1.5 years before they can actually arrive in Sweden. Another thing with the different tax regimes is that they might result in actual termination of tax agreements. We have a current example there because when Greece introduced their current special regime, because Sweden actually just a few weeks ago sent a message to the Greek government that Sweden is terminating the Swedish-Greek tax treaty. And we've sent the same notification to Portugal. Worst case scenario, we will end up in a situation where we don't have a tax treaty to fall back on after a relocation. That's not only Sweden, and I'm not sure whether there are any other countries involved today that has experienced that, but I know our neighbor Denmark terminated the tax treaties with Spain and France, and that was several years back, and they still don't have any new treaties. Thanks for your time. Now over to Christos for the Q&As.
So I'm pointing out that you mentioned the most important issues are immigration, tax issues, permanent home, and also the tax treaty. However, if I got it correct, the most important is the spouse, so the woman's rule the world. What is your view on this?
It is in principle that's correct. But the thing I want to stress is that do not make a relocation that is purely tax driven. You must consider all the implications as well. And I know, of course, I understand that in some situation it is tax driven. I mean, if you can make like £1 billion or euros on a move, you can save a lot of money. But it's important to look at the authorities are looking at those situations as well, and all the tax treaties, at least within the European Union, are being amended as we speak, slowly. And there is introduced another article in the tax treaties in order to, which says that if the main reason for the move is to actually gain a tax advantage, then the treaty is not applicable. It's more of an anti-abuse article.
Yeah. So thanks, Anders, for providing a different perspective to this webinar, not just the tax reasons, but also other reasons that might end up with relocating, and tax might go well, but other issues might face difficulties, and the clients need to know that. So let me move on to the Q&A sessions. We have some questions that our attendees, and feel free to pose your questions here. We have another 10 minutes, so it will be great to ask questions. One of the questions that we have here is that is about trust. So what will be the best location for trust taxation? Trust, because they are typically on common law jurisdictions. Perhaps Jonathan and Kostas would like to answer this question. The actual question is about which country has the lowest tax rate on trust distributions. I know that the UK and Cyprus have a similar legislation, but quite different. So do you want to comment on this?
Yes, Christos, if I'm allowed, Jonathan, to go first, explain a little bit. It's very complicated matter indeed, the trust, for various reasons, but very quick, what I can say is that there are, from country to country, it differs how they treat trust. So where trust has income, and then you need to identify who is the taxable person, since the trust is not. In some jurisdictions is the trustees. In some other jurisdictions are the beneficiaries. Some jurisdictions, they tax the income as soon as goes to the trust. Some other jurisdictions, they go, for example, Canada, they defer tax till the distribution. This is Canada and the US, usually these two jurisdictions. So now in Cyprus, any income received by the trust is considered to be received by the beneficiaries and taxed accordingly, regardless if it was distributed or not. So if a trust receives, for example, dividends, and keeps them till distribution, then these considered to be already distributed to the beneficiaries and taxed accordingly. For example, if the beneficiaries are not in Cyprus, Cyprus does not impose withholding taxes, so Cyprus will not tax at all.
Thanks, Costa. So if I were to put a UK hat on and look at trust, it depends on the type of trust, but similar to Cyprus, there can be some instances where you receive value from trusts and be subject to the special form of taxation in the UK for non-domiciles. So it's always important to understand, as Kostas mentioned, the type of trust to determine how it's going to be taxed. Is it going to be is it the settlor who set up the person who set up the trust who's taking the money out? Is it the beneficiary who's taking the money out, or is it going somewhere else? It's always useful to understand where you need the money, but you may be able to claim the remittance basis, which is the non-domicile special regime, which means that if you claim that status and you post the proceeds offshore, not in the UK, and you don't bring that money to the UK, then you may be able to be exempt on that.
Okay, guys, many thanks for your input. We have another question that it was slightly discussed before, but it's good to bring it on board. The question is, Sweden wishes to terminate the double tax agreement with Greece, and whether this happened with other countries as well. It's good to start with the implications of Greece, and then move on to Anders to provide us his feedback. And if you can also comment, for example, what are the options? I mean, double tax treaties are governed by public international law. So if a country revokes a treaty, the only option is to go to the International Court of Justice, which to my memory, this never happened again. And I mean, until today. And I don't know what are the options of a country going to the International Court of Justice if another country revokes a treaty, and whether if you are in the EU, you have any other options. But guys, feel free to comment. I mean, from Greece perspective, and then Andres, you can also provide us your feedback on this as well.
Well, let me take this one. I confirm that Sweden has reacted in such a way against Greece. Actually, Greece, the Greek state, has not yet adopted an official position in this respect. But this reaction from Sweden, this reaction followed the introduction of the retiree tax regime, due to the fact that several types of income, which through the application of the DTC between Greece and Sweden, are exempt from Swedish taxation, such as capital gains and pensions, are in effect taxed at a very low tax rate in Greece, especially in the foreign retiree tax regime. So, well, a general comment would be that we hope that these regimes will last and will not bring tension between countries. Definitely, this is not something that we would like. And this refers not only to Greece, but also other jurisdictions which may have faced the same, let's say, issues with Sweden or other Scandinavian countries, if I'm not also on that one. Anders, I think you are the most suitable person to explain us the background for the reasons that Sweden or Denmark or other countries have proceeded with such actions.
Well, it's thank you. Well, it's quite easy, really, because or simple, because I mean, the true purpose is, of course, to try to keep the tax base, and the Swedish-Greece tax treaty is a rather old treaty, and it's one of the few treaties where Sweden has where there's still a lot of income that is exempt from taxation when you have treaty residency in this case in Greece. And when Greece then introduced the special tax regime, the Swedish Ministry of Finance were afraid that a lot of people would start moving to Greece and avoid taxation in Sweden at all. So there wouldn't be anything taxed, especially regarding pensions. And thus they sort of, most likely they thought that there isn't time enough to try to renegotiate any articles of the treaty, and there are too many articles, too many types of income that are exempted. So they went for the option to actually terminate the treaty in full. At the same time, when we look at Portugal with the NHR regime, there has been a lot of movement from Sweden to Portugal over the last years. And the NHR regime is, of course, one of the main reasons. And what Sweden did is when it comes to Portugal, we renegotiated the treaty, especially regarding pensions. The problem is that the Portuguese parliament has not ratified the changes yet. That's why Sweden terminated that agreement. And my personal thoughts is that the Portuguese parliament will actually accept the changes, and Sweden will withdraw the termination, because it's not a nice situation where you don't have a tax treaty. You will fall back on internal law, and Swedish internal law. It's hard to get out of Swedish tax residency once you have actually lived in Sweden, and especially if you have a lot of assets in Sweden and retain those assets. And the problem is we can't go to the European Court of Justice or anything like that, because direct taxation, that is an exclusive competence that lies with the member states. If we look at the European Treaty. So there we have problems, and I've seen in our neighbor Denmark, as I mentioned, they have terminated their tax agreements with Spain and France, and they did that. That must have been 10 years ago or something like that, but that wasn't caused by special tax regimes. That was caused by a ruling from the European Court of Justice against Denmark on pension contributions, on taxation of pension contributions to foreign pension plans. So that was a result. Denmark wanted to change the Article 18 of their treaties with Spain and France regarding pensions, and France and Spain said no. Then Denmark said, okay, then we terminate the treaty. So you will have to fall back on internal rules, which also, of course, increases the risk of actually ending up in a double taxation situation that cannot be solved.
Many thanks, Anders, for your insightful feedback on this question. We have another question which is very interesting. Let me read it for you and let's discuss this question, Anders. You mentioned that if an individual that moves to another country to get the privilege of the new regime there, like the NHR in Portugal or the UK or Cyprus non-domicile regime, there is a risk that the treaty will not be applicable either under Article 4.1, since the taxpayer will not be in a position to be taxed at all, or under the General Treaty Anti-Abuse Principle. If I am understanding the question correct by Lucas, Article 4.1 of the treaty sends you back to the domestic law to be considered as tax resident. So if you are tax resident under the domestic law, automatically you are also tax resident of the treaty. So you can have access to the treaty and get the benefit of the time breaker rule. Have you seen, if this is a question, have you seen any issues that you might be considering a country resident under a special regime, but at the end of the day you will not be considered treaty resident? Can you please elaborate more on this point, Anders?
I have an example, and that is between Sweden and Spain. Unfortunately, we don't have Spain with us today. And that is because if you are, Spain they have their Beckham rule, the special tax regime, the Beckham regime, and that means that you are a resident in Spain, but you're treated as a non-tax resident. And in the Swedish-Spanish tax in the tiebreaker rule, it's specifically mentioned that when you see whether you are tax resident or not under stage 1 under the tiebreaker rule, you are not to be seen as tax residents if you're only tax resident taxable on income from that state. And when you're under the Beckham rule, you're seen as non-tax resident, and you're only tax liable in Spain for income that is generated in Spain. So there, if you move from Sweden, relocate from Sweden to Spain, we haven't tested anything in the courts yet, but we mean that there is a very big risk that the Swedish tax agency would say that they are not tax residents in Spain, but they remain tax residents in Sweden due to internal Swedish law, keeping essential ties to Sweden, and therefore they fall back to treaty residency in Sweden already on point 1. So it doesn't matter, even if they don't have any actual housing in Sweden, they still fall back with a treaty residency in Sweden due to the first step in the tiebreaker. Normally, you just end up directly in step 2, that is look at whether you have access to housing or not. But you actually always have to start on step 1, which is, are you tax resident in both states?
Yeah. So let me elaborate the question to see whether we have answered it to our friend Luca Tagliatella. Is that if you join this special tax regime, you will be considered treaty resident under paragraph 4.1, but you will most probably be the losing state under the paragraph 4.2, where is the tiebreaker rule of the tiebreaker of individuals, correct? Or this is something different, if I understood the question correct of Lucas.
Okay, so that was directed to me. Oh, I thought you Luca in Italy. Sorry.
No, it is not Lucas, our speaker. It's another Lucas.
Oh, okay. So sorry. Could you well, if I got it right there, that as I mentioned, the problem is that you never end up in step 2 in the tiebreaker rule. You end
when
up.
you say step 2, and there's just to understand it better, you mean step 2 being the center of vital interest?
No, that is step 3. Step 1, when we look at the tiebreaker rule, step 1 is tax resident in both states or not. If you're only tax resident in one state, then you're, of course, have treaty residency there. That is step 1. Step 2 is access to permanent housing, and step 3 is center of vital interest, and then step 4 and 5 and so on. But now, of course, I'm not talking about tiebreaks tax treaties that are modeled after the OECD model treaty. There are still old treaties that look completely different, but that is the most standard tiebreaker rule. And we end up in this situation. So far, I've only seen it with Spain, but I would say that there might be a risk that you have that in other countries, because I'm pretty sure that other countries will follow introducing different special tax regimes in order to attract high net worth individuals and retirees. I mean, once one country starts, then another follows, and then we got the snowball rolling.
Yeah. Many thanks, Andres, for your feedback. We need to close this session. We are already over time. The candidates are very excited of popping up questions. So thank you all for turning into today's sessions, and we hope you enjoy our insights and our practical advice. Please keep an eye to your inbox for our future webinars in Taxan. And as a reminder, the speaker profiles are there on our PDF if you want to contact with our speakers for any more questions. If not, you can still drop an email to taxan@taxan.com, and our people there will redirect you to appropriate contact. Enjoy the rest of the day whenever you are, and see you soon, either in a webinar or physically elsewhere. Take care, and many thanks to everybody. Bye-bye.